Okay, a great little book here. This is called Constitutional Law as Fiction by LaRue, Narrative and the Rhetoric of Authority. He doesn't necessarily talk bad about having fiction and law. He's more or less just teaching us how to spot narrative or fiction and law, and this goes along with what I've been talking about lately as far as theatrics and jurisprudence, which then I called juris drama, juris theatrics, juris play. So this is kind of the best setup I could come up with. And I just want to read through chapter 1, part 1 only, where he talks about storytelling. And if you want to just listen while you do some work around the house or driving or whatever, that's fine. You don't really need to see the words. But I looked all over online for this book to see if I could find a PDF of it, and then I could just read from it right on the computer screen where people could see and download the book themselves, but I couldn't find one. So you can buy these online. They're anywhere from used about $8 to new around just under $50. I think I got this one on Amazon. I'm going to do my best to read this in a kind of a slow, well-read way, so that if you're just listening to it, it sounds right and you can make sense of it. Okay, so chapter 1, part 1, storytelling. The title of this book, Constitutional Law as Fiction, summarizes my thesis, which is that the proud towers of the law are built not on the level bedrock of fact, but on the perplexed terrain of fiction, that judicial opinions are filled with stories that purport to be factual, but that instead are fictional, and furthermore that these fictions could not be eliminated without crippling the legal enterprise. By the way, I acknowledge the ambiguity of fact, fiction, and story, but in due course hope to explain what I mean by these words. My claim that legal discourse is made of stories that are fictional will strike many as curious. Since legal discourse does not obviously resemble the short story or novel, for example, a judicial opinion customarily cites other cases that seem to be relevant precedents. Novels and short stories do not usually start by citing precedents. The practices of stating an issue or citing a rule are also central to legal argument, but rarely found in novels or short stories. Indeed, the average judicial opinion follows a standard format that differs sharply from that used by novelists. Consider, for example, the typical opinion in a court, such as the Supreme Court of the United States. It usually begins with the procedural history, a summary of what has happened in the trial court and the intermediate appellate court, and an event history, a summary of the out-of-court facts, namely the events that generated the case or suit. The order in which these two summaries are presented may vary, but they customarily come at the beginning of the opinion. I can illustrate this common pattern by quoting from Everson v. Board of Education, which I shall return to later in order to illustrate the thesis of law as fiction. The opinion begins as follows, with events first, procedure second. Mr. Justice Black delivered the opinion of the court. A New Jersey statute authorizes its local school districts to make rules and contracts for the transportation of children to and from schools. The appellee, a township board of education, acting pursuant to this statute, authorized reimbursement to parents of money expended by them for the bus transportation of their children on regular buses operated by the public transportation system. Part of this money was for the payment of transportation of some children in the community to Catholic parochial schools. These church schools give their students, in addition to secular education, a regular religious instruction conforming to the religious tenets and modes of worship of the Catholic faith. The superintendent of these schools is a Catholic priest. The appellant in his capacity as a district taxpayer filed suit in a state court challenging the right of the board to reimburse parents of parochial school students. He contended that the statute and the resolution passed pursuant to it by the school board violated both the state and federal constitutions. That court held that the legislature was without power to authorize such payment under the state constitution, 132 NJL 9839A 2D 75. The New Jersey Court of Errors and Appeals reversed, holding that neither the statute nor the resolution passed pursuant to it was in conflict with the state constitution or the provisions of the federal constitution in issue. It is also customary for the author of a judicial opinion to state at the beginning of the opinion a summary of the issue presented for decision. Once again, I shall use Justice Black and Everson as an illustration. The only contention here is that the state statute and the resolution, insofar as they authorized reimbursement to parents of children attending parochial schools, violate the federal constitution in these two respects, which to some extent overlap. First, they authorize the state to take by taxation the private property of some and bestow it upon others to be used for their own private purposes. It is alleged, violates the Due Process Clause of the 14th Amendment. Second, the statute and the resolution forced inhabitants to pay taxes to help support and maintain schools which are dedicated to and which regularly teach the Catholic faith. This is alleged to be a use of state power to support church schools contrary to the prohibition of the First Amendment, which the 14th Amendment made applicable to the states. In short, judicial opinions do not look like fiction. Their authors do not believe that they are writing fiction, and their readers, other judges, lawyers, law professors, and law students, do not normally imagine that they are reading fiction. Instead of describing their work as writing fiction, most judges would say that deciding cases is their primary responsibility. People bring their disputes to court, and if they are unable to negotiate settlements, they submit their disputes to a judge or a judge and jury. As one goes up the judicial ladder, the focus on deciding cases remains, but an additional function, declaring and clarifying the law, becomes important. When we get to the United States Supreme Court in a case like Everson, which I have just cited, the responsibility of declaring law becomes primary. In this book, I limit myself to discussing Supreme Court opinions. Those who declare law have an awesome responsibility, especially when they must declare constitutional law. We expect of them, and they expect of themselves, caution, care, and meticulous attention to detail. Look back at the two paragraphs I have quoted from Everson. The procedural and event histories are short and incomplete, but also quite specific and concrete in the details. This quality of meticulous care is normally present in other parts of the standard judicial opinion. Precedents are cited and quoted from, with care to get the page numbers right, the issue is stated in a pedantic, almost fussy manner, and in general, the prose of the opinion is normally perceived as dense and technical. Hugo Black's prose differs from that of most judges by being far more colloquial than is customary, and so Black does not illustrate all of my generalizations. However, I wish to argue that one should not be misled by judicial prose into believing that constitutional law is a technical enterprise. Instead, I suggest that one should listen for that moment in legal discourse when a story is told. These moments are crucial. Judicial opinions must be persuasive if the enterprise of judge-made law is to have the power that it has. Lawyers and judges need to believe in what they do. The spirit and self-confidence of the judiciary rest on their belief in the rectitude of their enterprise. Since persuasion is so important, my metaphor, law as fiction, is apt. Without persuasion, law could not be law, and without fiction, there would be no persuasion. I hope that the above establishes the topic. If so, let me now state 2 qualifications on the scope of my inquiry and on how I understand my thesis, law as fiction. First, the phrase, law as fiction, is intended as a description. And describing law as fiction is merely one of many ways to describe law. For example, we can describe law as a process for settling disputes, or as a way of organizing power, or as an expression of the underlying social structure of our society. In this book, I shall not examine the merits, which are many, of these alternative descriptions. Instead, I shall try to explain my own. However, it is surely worthwhile to pause and consider a problem of descriptions. There is a fundamental error here that must be avoided. One must avoid the superstition that any one description will necessarily or logically exclude any other. If I describe a man as tall and heavy, I should not be understood as denying that he is graceful and quick. So too, if I describe law as the way those with power have organized and coordinated their power over the rest of us, I should not be understood as denying that law is also a necessary technique for resolving disputes. Both descriptions can be true. To be sure, if I say that a man is tall, I have excluded the possibility that he is short. Furthermore, even though a man is tall, he can weigh less than a short man. The odds are that he will not. Thus, the description of a man as tall does not exclude this description of a man as light, but it does make it less likely. Similarly, 2 different descriptions of law could be logically compatible, but unlikely. How, then, should a reader understand my claim that we can describe law as fiction? Are there other descriptions with which it is logically inconsistent? And are there descriptions with which mine could coexist, but is not likely to? The thesis of law as fiction can coexist with other theses, such as law as power or law as violence, as the late Robert Cover has argued. For example, one might say that the stories told conceal the violence of the law, or somehow enable the law's actors to do violence with a good conscience. However, I do not try to work out such links in this book. Instead, I limit myself to the fictions that are told. Even within these limits, and allowing for the possibility of multiple alternative descriptions of law, my thesis that judicial opinions contain fictions that are absolutely essential to the business of judging is inconsistent with one fairly common analysis of judging, which goes somewhat as follows. Those who judge start with rules which they derive from their reading of cases and statutes. But the rules standing alone are not sufficient. In order to use rules wisely, judges must consider the purposes behind the rules, namely the principles and policies that make the rules appropriate and rational. Giving a citation here is almost foolish, since one could easily assemble a book-length bibliography on the many variations of this standard thesis, so I will limit myself to the book from which I was taught. The standard thesis reflects the obvious that judges do talk about rules and purposes, about principles and policies, but errs in asserting that this rationalistic account of judging subsumes the necessary and sufficient conditions of judging. I assert that stories are necessary. Second, not only is the phrase law as fiction just one out of many possible descriptions, it is merely a description and not an evaluation. I know that many people consider the word fiction pejorative. Fact is good and fiction is bad. But I think that the truth is much more complicated than that. I will not take the high ground and argue that Shakespeare and Sophocles tell more truths than those who purport to be factual. They do, of course, but my thesis is far more pedestrian. And so I shall proceed on a lower level of discourse. The complexity of good and bad in fiction arises from the tangled meaning of the curious word. In this book, I use the word fiction in the same way that it is used in common speech, but with a twist. Let us start with ordinary usage. As I understand our everyday speech, a fiction is a story about something that didn't really happen. The American Heritage Dictionary of the English Language puts it more formally: a literary work whose content is produced by the imagination and is not necessarily based on fact. Ordinary usage, which I have described informally as a story about something that didn't really happen, is necessarily the place to start, but it would be disastrous to leave it at that. Consider my dictionary's statement that a fiction is produced by the imagination and not necessarily based on fact. This dictionary definition is unsatisfactory because it implies, without clearly stating, a sharp dichotomy between two kinds of stories: those produced by the imagination and not necessarily based on fact, versus those not produced by the imagination and necessarily based on fact. However, this dichotomy may not exist. We can produce stories without using the imagination, and it is possible to have stories that are based solely on the facts. If not, then almost all discourse is fictional. Or, if I may put this thesis more cautiously, most discourse is in part fictional. Consider, for example, history. Historians write accounts based on fact, but good historic accounts are also produced by the imagination. When historians try to explain the course of events, they must compare the several different explanations that are possible, and they must try to say why one explanation fits the facts better than another. But where do the explanations come from? The majority of historians do nothing more than struggle with the explanations of their predecessors have bequeathed to them. We honor as great, however, those who extend our knowledge by the strength of their imagination. We honor those whose explanations are new, challenging, and enlightening. American historians who exemplify this trait include Frederick Jackson Turner, whose frontier thesis revolutionized the study of American history, and Francis Parkman, whose vast imaginative powers enabled him to create an exceptionally vivid account of the French and Indian Wars. Furthermore, the imagination is not limited to proposing hypotheses, which the facts then adjudicate. Would that life could be so simple? The witnesses who wrote the documents that historians use may have been biased, so that one must cross-examine these documents carefully, and one must have a good imagination before one can ask good questions. Even after we have accepted certain documents as trustworthy, they may be ambiguous or incomplete on crucial issues. But one cannot be sensitive to ambiguities or absences without imagination, and furthermore, resolving ambiguities and restoring absences are creative, imaginative acts. If all accounts have fictions that cannot be removed, then fact and fiction are not dichotomies. Every story will have some of both. Our honorable ambition may be to present facts, but human limitations will frustrate us. We will never tell a story that is not fictional in part. If this be true, if fact and fiction are necessarily intertwined, then it follows that the word fiction should not be a pejorative. If fiction is necessary, then it is idle to condemn it. However, not all stories are equal. Some are better than others. As we examine the stories that judges tell, we find here too that some are good, some are bad. Judges tell us these stories to persuade us that the path of law should run one way, not another, and we may be persuaded on some occasions, but not on others. Furthermore, the ratio of fact to fiction in all story does not correspond to the ratio of truth to falsehood in it. After all, we can never know facts with certainty. We are limited to probabilities. As every lawyer knows, eyewitnesses can be mistaken, and there is a margin of error in laboratory tests. In short, the facts in a story are never simply true. Rather, they must be considered more or less likely. Moreover, even if our facts are probable, they may be incomplete and thus misleading. For example, suppose it to be highly probable that a worker who was fired gave speeches that the boss despised. This short statement is necessarily incomplete. Suppose further that this worker fought with coworkers at the workplace, and note how the fact changes the possible stories. In other words, an incomplete set of facts, even if all the details are true to a high degree of probability, will suggest to us a story that is likely to be false. And conversely, just as a mass of facts need not guarantee a true story, imagination need not generate falsity. A story only marginally supported by the facts or largely generated by the imagination may yet be true. In the simplest case, imagination can make a lucky guess, which later investigation corroborates. In more complex cases, a discerning imagination may be our only guide to truth. Further investigation may be impossible because the evidence is lost. Witnesses may have died, records may have been lost, physical traces may have deteriorated. And if the key facts concern human intention, whether an act was malicious or merely thoughtless, then imagination may be the only possible guide into the workings of the human psyche. In the above, I have used the word story without defining it. I have suggested that a story can be true even though largely fictional, but I have not clarified how I am using the word story. Fortunately, to use so casually a key word like story is harmless, since legal stories are far less complex than novels, plays, or narrative poems. Judges do not like to write like Joyce or Borges. Consequently, I think it best to keep the analysis as simple as possible, and I shall do so by accepting a straightforward definition that the novelist Reynolds Price has asserted. In his discussion of biblical narratives, Price states, "From Genesis, we gather that Adam invented narrative. When God hunts out the human pair after their fall, Adam says, "I heard your voice in the garden and feared, since I am naked, and hid myself." A chronologically consecutive account of more than one past event, with attention to cause and self-defense, thus a narrative. Price's elegant summary works for legal stories, all of which attend to chronology, causation, and evaluation. For purposes of this book, nothing more complicated is needed. The foregoing constitutes the abstract part of this introduction. Let me now be more concrete. To illustrate the presence of fiction in the law, I discuss a few of the key cases governing the church-state relationship. I start with an attempt to show that the legal discourse about law and religion includes stories along with other more familiar topics. The familiar topics in the field of law and religion include legal dissection of the leading precedents, philosophical puzzles about the difficulty of defining religion, sociological analysis about the place of religion in American life, political judgment about whether religion divides or unites us, and historical discussions about how things have changed or not changed. The discourse on any of these themes can be broadly theoretical or intensely empirical, but whether theoretical or empirical, a funny thing seems to happen along the way to the conclusion. No matter how a discourse starts, sooner or later, the analyst slips into the narrative mode. For instance, even in the writing of Immanuel Kant, narrative is inserted into that blank place where the presumed purely conceptual language of philosophy fails or is missing. And if an abstract thinker like Kant must use narrative, then everyone must. Are these stories more illustrative or embellishments? Are these stories mere illustrative or embellishments? Or are they the deep structure of cognition on which the theory rests as mere superstructure? My own hunch is that the latter is true. Although this assertion is not easily proved or disproved, instead, let us turn to the legal discourse on law and religion and listen to the stories that are told.